Ladies and gentlemen, this is a celebration live stream. It is basically official. The Supreme Court immunity ruling, but also the fact that the DOJ and the FEC dropped the hush money case gives Trump the league of victory. The conviction is going to be overturned either by the appeals court on a federal level or by the Supreme Court. Hit subscribe to this channel right now. This is huge. Go to H.A. Goodman's other channel after this. I will have a live stream, upload on that channel immediately after this. This is amazing. We'll get to why the Federal Court of Appeals, or one of the appeals courts, will overturn the guilty verdict. This is really amazing. A federal appeals court in New York on Thursday said the president, Donald Trump, should be allowed to make a case why federal courts should review his hush money conviction for possible conflicts with the Supreme Court's landmark immunity decision last year. The DOJ dropped the hush money case. That's why. The federal government already dropped any charges against Trump because there weren't any. And you'll hear that in a second. That's what this is. The Federal Election Commission is not a state, is not a department of New York. It's not a state agency. It's a federal agency. The state leveled FEC crimes at Trump. Game, set, match. It's unconstitutional. A state would need the Department of Justice to level federal crimes at President Trump, and the state can level state crimes. What they did in this conviction is they unilaterally stated, oh, the state of New York has decided Trump committed campaign finance violations, even though the Federal Election Commission and the Department of Justice dropped the case. That's blatantly unconstitutional. Hit subscribe to this channel right now. Gets to the Supreme Court, 100%. It'll be overturned, but it could be very well overturned before it even gets to the Supreme Court on the federal level because of this. This is the former FEC chairman, Hans A. von Spakovsky. Check this out. Hit subscribe if you're new to my super chat. Thank you. This is huge, people. The conviction is pretty much done. Null, void, erased. The whole thing was political.
Reaction Francis Hakes does. This is a travesty, a miscarriage of justice. This was a phony prosecution from the very beginning. And for this jury, think about how many weeks this trial went on, how many witnesses came in, and in the very short time that the jury was out, they decided he was guilty on all 34 charges. This is a damage to the reputation of the American justice system like we have never seen. I have a colleague just got back from a conference overseas, and the reaction of lawyers and people there was that the United States has now gotten to be like the countries they are from, where the government uses its law enforcement powers to go after its political opponents. And that, I think, is exactly what happened here.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, you know, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake that at the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately, because
this is a federal case. This is jurors in New York City deciding that Trump committed a federal crime. That's not it's unconstitutional. You cannot have a state decide what the Department of Justice should have decided. So you can't do that. It's unconstitutional. Federal law usurps state law. And the federal government, in this case, the FEC, dropped the case. So if the Federal Election Commission dropped the case and the Department of Justice, alongside the FEC, didn't level any charges, they dropped the case as well, how on earth is Trump going to be convicted of Federal Election Commission crimes when, by the way, they weren't even crimes? You'll hear other FEC chairmen state they weren't crimes. He could have paid Stormy with dollar bills. They said 34 charges. Those are 34 payments Michael Cohen made with checks that he, using his own money in a shell corporation that he started, not Trump. Well, let's continue. But even if Trump used his own money, it wasn't a campaign finance violation because theoretically one would have paid Stormy with or without running for president. That's what makes it a campaign finance violation. The Steele dossier is a campaign finance violation that was specifically purchased to ruin Trump's presidency or election chances. Let's continue.
Because of this and so many other mistakes made in the case.
How many do you count? How many mistakes?
I lost count of how many errors were made by this judge and by the prosecution. I mean, the judge let in all kinds of irrelevant evidence that had no bearing on the charges against the president, but were obviously there to blacken the character of Donald Trump. The judge shouldn't have even been on the case. He should have recused himself because of his personal family dealings, his daughter's involvement, his making political contributions in violation of the ethics rules in New York. There are just so many mistakes and errors he made that I don't see how a court of appeals could not overturn this verdict.
So John Yoo, legal scholar, also agrees. Check this out. And so this is a done deal, ladies and gentlemen. Once it gets to the Supreme Court has already overturned convictions of this sort, but this is unconstitutional because a state leveled an FEC charge.
Welcome back, America. We're here with our friend John Yoo, really one of the foremost legal scholars in the country. Former Deputy Assistant Attorney General, UC Berkeley Law Professor, Hoover Institution, visiting fellow, and all-around great guy. John Yoo, you see this case in Manhattan. How bad is it for our nation? How bad is it for our electoral system? How bad is it for the rule of law, for federalism, the whole kit and caboodle?
Mark, thanks for having me back. I am saddened at what this case has now done to our political and constitutional system. It's hard to exaggerate the harm that it's going to do, not just to Donald Trump. He's important, but the more important question is, what does this do to our institutions? As you said, our legal system, our electoral system, our system of federalism and the separation of powers for all future presidents, for all future citizens. First, we have never prosecuted a former president before. This was not because past presidents hadn't done anything bad. It's because we thought it was the best thing for our separation of powers to leave presidents alone. And the reason why is because the Constitution concentrates so much responsibility and authority in the president to take care that the laws are faithfully executed, to protect the country from foreign threats, that we don't want our presidents, when they're making the hardest decisions on behalf of the country, to be worrying about whether they're going to be prosecuted or not. We don't want our presidents to be insurance claims adjusters worrying about risks and balances of their own personal finances and their own personal legal situation. We want them to decide what's best for the country. Now, because this case was so frivolous, because it was based on such concocted legal theories, it opens the door wide now for any DA, and there are 2,500 of them in the country, any DA to sue and prosecute any president, any past president, perhaps any sitting president under the theories that were put forward earlier. I think an even worse problem is for the rule of law. Because what we've all learned now, I think, is that prosecutors can destroy a person. They can destroy a person's reputation, his finances, just by investigating them, even before they get to court, just by publicly announcing that they're investigating someone. We have for 230 years relied on prosecutors, on our elected chief executives, governors, and presidents to show, again, statesmanship, to go show good judgment, not to abuse this power. But now what we've seen is that I think the Biden Justice Department and these blue city DAs are abusing this power not to try to stop crime, but to target individuals because they don't like them, because they're unpopular, and then to find the crimes to fit the man. That is directly a direct assault on the rule of law. And that harms all of us in the country, all the citizens, not just Trump, not just presidents, but you and me and everyone else.
And what about the electoral system when you have one of these DAs deciding that they get to decide?
So the 10th Amendment is at play here. A state cannot level a federal charge or without the federal government involved. The 10th Amendment states that the federal government, if it's the FEC in this case, must level the charge against Trump, not a state court. If that were the case, any state court, any city or state judge or court in the country could level crimes at Clinton, Comey, and say, oh, well, you know what? We view that they committed a federal crime within our state. So therefore, we're going to level a federal crime without the Department of Justice and without, any agency linked to the specific crime. So that's blatantly unconstitutional. Hit subscribe if you're new. Go to H.A. Goodwin's other channel after this. We'll have an upload on this. The Trump conviction is done. It's basically erased. And that's going to be a huge day for the country and for U.S. history, because that was the only thing that they possibly, he's a convicted felon. No, he was never a convicted felon. None of the millions upon millions of Americans who gave Trump a landslide victory thought that he was a convicted felon. If anything, the people on the side he was against, we know, convicted or not, committed crimes.
Or try to decide the outcome of an election through the process. They can make a ambiguous reference to federal law, seize jurisdiction from what is a complex layer of federal authorities and decision makers when it comes to federal election campaign law, let alone seize the authority from federal courts and the Supreme Court to make these decisions, regardless of what the New York courts say up and down the chain. I mean, whatever the New York courts say up and down the chain, that is not the final decision. If the federal Supreme Court decides to step in, that's the final decision for you, New York. So if I'm in California and I see that it worked in New York because we have this lumbering appellate process, but I can interfere with an election, by the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States, and the election there too, no?
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission.
Only the federal government can enforce federal law. That's why they had Tammany Hall. That's why they had a court, DA, prosecutors, all liberal Democrats. And then they say Trump's going after his political opponents. They literally tried to imprison the Republican candidate for president. Imagine. And then they're up in arms and, oh my God, indignant. Oh, Trump is going after his political opponents. Yeah, they committed perjury. Very simple crimes. Perjury, conspiracy, 18 U.S. Code 371. They faked, they conspired to accuse Trump of things he didn't do, utilizing a dossier Clinton purchased, who, by the way, she got the DNC and Clinton paid an FEC fine. It's the Democrats that paid the Federal Election Commission fine, not Trump, for Stormy. That wasn't even a crime.
Can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism. And the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back, John Yoo, that is my question. So
So you heard that the Supreme Court will reverse this, and it's already going to, you saw the CNN article, it's already going to a federal court. Okay, so once it gets to a federal court, because these are federal issues, the Federal Election Commission is part of the federal government. Okay, I think it's part of the DOJ, but it's part of the executive branch. Okay, but and DOJ is part of the executive branch, but this is a huge victory. Okay. Federal Appeals Court in New York on Thursday said the president, Donald Trump, should be allowed to make a case for why federal courts should review such money. The federal courts are going to take this on. It's going to get to the Supreme Court. If it doesn't get overturned immediately, it'll get to the Supreme Court. They'll overturn it. But this is pretty much a done deal. This is huge, ladies and gentlemen. This is really huge.
Trump's indictment looks like a perversion of campaign finance laws. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more, and it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard, it's an objective one. So if I go out and I want to pay for TV ads that say, you know, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit. In your op-ed piece, it was $4,000, but I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun, but your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever, you're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It has to be an expenditure that only would be made during a presidential election. That's not the case with payment to Stormy. those types of confidentiality agreements have taken place for a lot of different situations. If Stormy and any billionaire could have had a romantic relationship, she could have paid the money, or anyone in her position could have paid or could have signed a confidentiality agreement, accepted money, and you wouldn't have had to have had a person running for president to pay Stormy money. That's why it's not a campaign finance issue. Even if people say, well, people will find out and they won't vote for Trump. Nobody cared. People want Trump for great economy, better economy, foreign policy, immigration laws. President Trump stands for policies Democrats don't stand for. So it wouldn't have mattered if people found out that there was a potential affair. Nobody would have cared. But if the rebuttal is, well, he wanted to protect his campaign, that's not a rebuttal. It's still not a campaign finance issue. That's why the FEC dropped the case. The Federal Election Commission dropped the case. If he had purchased a dossier stating that Hillary and Bill and others were in a Moscow hotel room, then it would have been a campaign finance issue because the DNC and Hillary Clinton paid an FEC fine. Then it would have been a campaign finance issue. But anyway, this is former FEC Chairman Bradley Smith will explain better than me.
It actually goes further than that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not, right? And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds.
It was Michael Cohen who created a shell company and used his own money. And there's no evidence that Trump told him to do so. Michael Cohen stated that he had, so many recordings of Trump. Notice how there's no evidence of Trump telling Michael Cohen to open up a company and pay Stormy Daniels. But Cohen's testimony is, well, I did that because he wanted me to, but there's no evidence. But even if Trump told him to do so, it wouldn't have been a campaign finance violation.
And that's, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of the law.
Well, but how does that get up to the Federal Election Commission, which has already turned this case down once?
So now listen to this, ladies and gentlemen. This is why this is a celebration live stream. That conviction is done. It's essentially already thrown out, people. And I've been telling you this from the second that he was, quote unquote, convicted. That was the greatest farce of all time. But check it out. Listen to this. This is important.
Right. Well, this raises yet another question. Can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice have thought it was not a violation of federal law. So,
and that, for anyone wondering, for any morally superior liberal Democrat or progressive or leftist who said he was convicted, that's exactly what Bradley Smith stated is exactly why the hush money conviction was purely partisan, highly unconstitutional, overtly unconstitutional, and basically already tossed out with today's news. A state cannot level. It's the 10th Amendment. A state would need the Department of Justice to level a Federal Election Commission crime at Trump. The DOJ and FEC dropped the case. They dropped the hush money case because what happened was not a campaign finance violation.
So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
We don't know that.
Manhattan DA says he will not appear on Capitol Hill today as House Republicans hold a hearing on former President Trump's New York trial. Bragg citing scheduling conflicts. He is set to testify, though, on July 12th, just one day after Trump's sentencing. Federal Election Commission.
And by the way, the two men to the right, the Federal Election Commission Chairman Trey Traynor and the former Missouri AG Andrew Bailey, who's now the number 2 along with Dan Bongino at the Federal Bureau of Investigation. That should tell you about upcoming indictments. And John Brennan, when John Brennan gets indicted, please go ahead and watch H.A. Goodman on YouTube. Hit subscribe to this channel if you're new. Go to H.A. Goodman's other channel. It's in the description right after this. I'll give you a synopsis and upload of this live stream. Hit subscribe if you're new to my super chat. Thank you. Could talk about this trial or the overturning of Trump's conviction, anything within reason.
Commissioner Trey Traynor and Missouri Attorney General Andrew Bailey set to testify today at today's hearing, and they join me now. Trey, you notice I emphasized the election in your title. I guess we're finally set to hear from somebody who actually understands how election law works. Juan Merchan cannot silence you. What are the top points, Trey, you're going to try and drive home today?
Well, the most important point is that Judge Merchan completely obliterated what's been longstanding federal election law with the jury charge that he gave, asking the jury whether Donald Trump had willfully contributed to a campaign. And the legal standard has long been knowing and willful standard, so he's completely upended that standard. And it's one of those things where the Department of Justice should have intervened early in this case and protected the jurisdiction of the federal government to enforce federal campaign finance law. They didn't. They didn't protect the jurisdiction of the Federal Election Commission. And it's completely perplexing why they didn't do that. There's long-standing Supreme Court precedent that says that they should have.
And it's just how law works. People always fight over jurisdiction. They never give that up. And in this case, it was ceded so easily. Andrew, Democrats, of course, are going to try and flip the script, calling today's hearing playing politics. And they're going to make this point, Andrew, A.G. Bailey. They merely follow the facts and the law up there in New York City. How will you cut the legs out from under that argument?
Well, they bent the law to meet the facts in a specious legal charge. There's an unseemly amount of prosecutorial misconduct. And at the end of the day, what that does is it injects both statutory and constitutional violations into the process from the charging document onto the jury deliberations. And so this is a legally errant conviction. It's not a legally valid conviction. And that emphasizes the illicit nature of the witch hunt prosecution. And it's important that the American people understand that the goal here was never to convict President Trump of a crime. It was always to remove him from the campaign trail. Now, this is a presidential candidate that has a right to speak and that we as a people have a right to access. This has done immeasurable damage to our democratic republic, and we've got to hold wrongdoers accountable.
Let's focus on this Matthew Colangelo, Alvin Bragg dichotomy here at A.G. Bailey, because the number 3 star.
So this is in response to when they say, oh, Trump tweeted, he tweeted that Comey and Letitia James and others should be indicted. Democrats don't tweet. They just get a Department of Justice official to work alongside state prosecutors. So they direct the state prosecution by getting a federal government prosecutor, a Department of Justice prosecutor, to help lead the case. That's direct involvement. That's direct involvement between the Democratic Party and trying to convict Trump during an election year.
Starter right now in the Yankees rotation is not waving his hand and saying, please send me to single A so I can ply my craft. What possible reason could Matthew Colangelo, the number 3 at the Department of Justice, have to leave the DOJ, go down to the Manhattan DA, if not for his desire to help the Democrats and get Trump?
Yeah, the DOJ may not have intervened to reassert the jurisdiction of the FEC. That's the appropriate legal avenue for the DOJ. But instead what they did was deploy resources to the state of New York in the form of Matthew Colangelo, like you said, the former third-ranking official in Biden's Department of Justice who led the trial court prosecution against President Trump on behalf of Alvin Bragg. So he takes a pay cut to go work in state court. He's politically motivated. Those prosecutors should have been disqualified from prosecuting that case. There was no case to begin with. A subsequent prosecutor that the court could have appointed would have identified that and dismissed it.
There was no case to begin with. TBJ, thank you so very much, as always. TBJ, thank you. To my super chat, and I agree with you. They did fail miserably. I don't think so either. Those wins in Virginia, look, it's not like they're never going to win again. But Zohran Mamdani is the best thing to ever happen to J.D. Vance or Rubio in 2028 and President Trump for the next 4 years. Hit subscribe if you're new. TBJ, thank you.
Before it got this far. And again, Biden is behind this whole thing. I mean, he has managed the Department of Justice that also administers grants on behalf of the Soros-backed Vera Institute to Alvin Bragg's office with the intent of dismantling the criminal justice system. So while Alvin Bragg is ignoring crime in the subways and on the city streets, he is being trained to weaponize the criminal justice system against Biden's political opponents.
Trey, quick final word to you. If we don't stop this lawfare right now in its tracks, can our century-old justice system survive?
No, it can't. And we have a big threat to the First Amendment and whether or not candidates can actually run for office in any state, because we'll have turned loose all the prosecutors across the country, whether they be state or local prosecutors, to go after individual candidates for perceived violations of campaign finance law.
Thank you for what you're about to do on Capitol Hill today. The world, and especially our country, needs to hear.
So this is Bradley Smith and Greg Jarrett talking about how absurd the entire trial was, or even going after. This was years before the trial, but how none of this was a campaign finance violation or against the law.
To quiet the accusers. Non-disclosure agreements, if you will. Hush money. We can use the same phrase. They didn't want their constituents to know. Many of them running for re-election as incumbents. They're using tax dollars. It influences the campaign. Why aren't they indicted?
Well, we know why they're not indicted, right? Because we don't want to indict them. But no, it's a good example of things that influence the campaign. And it's worth noting that under the FEC's regulations, if you're an incumbent office holder, you're presumed to be running for re-election. So you're all presumed to be candidates unless they've announced that they're not seeking re-election. So they would be candidates, and this is something that they probably did to influence their future campaign or their perception as office holders. And one thing that's worth adding here, Mark, is because I hear this from people all the time, and even some other, election people who know election law, lawyers and some former other commissioners will say, yes, but it was to influence an election. But the FEC in its regulations very specifically rejected the idea that even as to whether it was primarily to influence the election or not. and choosing instead this test that it has to be an obligation that was created for the election. In other words, they didn't want to get into the question of trying to guess, well, did they do this primarily for the election or primarily for personal purposes? And it's very specific about that in the regulations. And I think that's a very important point that people need to keep in mind. And that was done actually to make it more objective and actually to prevent candidates from using their campaign funds for personal use. But, you know, that's the flip side. And I tell people, imagine if you're a lawyer for the Trump campaign and you want to do it all right. You've got one provision of the statute says I have to pay it with the campaign funds. Another provision seems to say I can't pay it with campaign funds. Somebody's going to get them coming or going, and that's part of the problem.
So if you're a lawyer for the Trump campaign or the coming Trump campaign, you would do pretty much what Donald Trump did. No campaign money, consult your private lawyer, and they enter into these non-disclosure agreements. Greg, let me ask you this. Isn't the real issue here is people were actually paid under the non-disclosure agreements and then they violated the non-disclosure agreements?
So they signed these NDAs. They signed, Stormy signed the non-disclosure. I think she lost that case to Trump, that she owed Trump money, something along those lines, but she signed the non-disclosure. She took the money. By the way, Trump ain't getting the money, or Michael Cohen. I guess Michael Cohen, who lied continuously, should get that money back, but he's not getting the money back. That's $100,000 that Michael Cohen gave to Stormy after Stormy signed, accepted the money and said that she's accepting the money. Apparently, that she's accepting the money and won't say anything. But that didn't work out.
I don't see them giving the money back.
Oh, you're absolutely right. I think it's malpractice for the attorney for Stormy Daniels to say, go ahead and talk while the case is pending as to whether or not it's a valid and enforceable non-disclosure agreement. So it's stunning to me. But to Bradley's point, not everything that benefits a candidate is considered to be a campaign expense. Professor Smith wrote that in one of his op-eds, and he's absolutely right. If there is a dual purpose or a secondary purpose, it's not a campaign expense. And moreover, the media rushed and said, oh, Cohen pled guilty, the president must be guilty. That's utter nonsense. First of all, under the Federal Campaign Election Act and other related laws that criminalize violations, there has to be knowledge. You have to show that there was a knowing and deliberate violation of the law in order for it to be criminal. Well, most candidates don't know the election law. Heck, a lot of lawyers don't understand election laws. This gentleman, the former commissioner, the Federal Election Commission, chairman, I mean, he knows election law. He may be just about the only one in America who really truly knows it. So,
and this is all a part of a crumbling attempt at trying to get Trump. Check this out.
Anchor of Life, Liberty, and Levin. Mark, it's great to have you with us. I just want to start by playing this soundbite to remind people what Letitia James said before she began the process of these prosecutions.
So, MSNBC, CNN, The Washington Post, The New York Times, all these publications that say Trump's his revenge tour, they were so vocal on getting Trump and denying his victory, his election victory, by the way. Check this out.
About President Trump.
To going into the office of Attorney General every day, suing him, defending your rights, and then going home.
I say one name, Donald Trump. That should motivate you.
Will you sue him for us?
Oh, we're going to definitely sue him. We're going to be a real pain in the He's going to know my name personally.
President Trump.
Will you sue him for us? Oh, we're going to definitely sue him. This is completely outlandish. Could you imagine if Trump or anyone that worked with President Trump said, oh, we're going to sue Clinton. Oh, we're going to sue Comey. Oh, you better believe it. I mean, it would be on instant replay on continual loop, 24/7 a day, 24/7 every second of the day.
Cannot avoid justice in the great state of New York.
Mark, your reaction to this decision today and the fact that it was partial, really?
Number one, she should be disbarred, and in any other state, she would have been disbarred. That's number one. Number two, this is a total victory, and I'll tell you why. If, in fact, the president or his companies or his family committed fraud, why would they get rid of every single penny of the decision? They threw out the $500 million fine because it violated the 8th Amendment, which applies to New York under the 14th Amendment, as I mentioned a year and a half ago, and that's a 5-year-old decision. It's called the Timms versus Indiana. So that's a given, and the court did the right thing there, and they knew that they had to do that. But the rest of it's going to get thrown out too, Martha, because it doesn't make any sense. How can you keep the underlying issues and then throw out the fine? So I went back, I read it. You got 5 judges. You have 3 opinions. You have Friedman, who makes the most sense. Then you have these 4 Democrats who are kind of fumbling around. They're not sure what to do. This opinion's hundreds of pages long, but they knew that this 8th Amendment violation was so blatant, it was so ridiculous, that even left-wing Democrat judges had to get rid of it. But then they say, we'll save a little face and keep some of this underlying stuff. That underlying stuff will not survive. The tail wagging the dog is the fine. The dog's going to have to go too. So the president is a total victory here, because what they did on the rest of the case can't stand, because it doesn't even make any sense.
It was always very personal for Letitia James. And after this decision, she would post on X day after day the amount of interest that was accrued to this judgment as well, adding up the dollars. We're going to put this up on the screen right now. So she would just put a number. It was sort of like a, half cute effort, I think, at, showing how much his fine was now. And you see Donald Trump Jr. responding to that. You mean 000. Thank you for your attention to this matter.
This is why President Trump won every battleground state, every swing state. He won the popular vote. He won the presidency after 4 years of Biden. They were telling us, oh, the adults are in the room. The adults were, God bless Biden, trying to funnel Biden, towards the door and trying to take care of him. That's what the adults were doing, unfortunately. And President Biden was forced out by his own political party. It's so embarrassing and yet so normal for Democrats. And in Virginia, they won, but the Virginia Democratic Party is a very strong political party. So, okay. And in New Jersey, they won. The incumbent was a Democrat. Okay. President Trump almost won New Jersey. President Trump almost won the Hispanic and Latino vote nationwide. On a national stage, Zohran Mamdani is the best thing that could happen to President Trump. The absolute best thing that could happen to J.D. Vance. My God. Oh, my God. Thank God Mamdani won. It's the best thing. So, do they take back the House? They should. So what? They'll have to defend about 20 to 30 indictments from now until next November. So they'll have to defend all of those indictments. And it's like President Trump, we have 4 years, thank God, again, of President Trump, and we'll get 4 years after 2028 of J.D. Vance. We could get 8 years of J.D. Vance. Who's nationally on the stage? We have 1,000 people plus. Give me a name. AOC? Mamdani? Mamdani 2028? They should. Why not? If hopefully he does a great job with city-run grocery stores and rent freezes and defunding police. That should be fantastic for New York. I mean, look, I love New York. I wish New York was the best. I do hope that he's successful. I hope that I'm wrong. I don't think he's going to be very good for that city. But anyway, let's continue.
Address that sort of, which others besides me have called very unprofessional behavior in this case, and how that should be addressed.
Well, I'm glad she got her math down, because one day she may be behind bars and have to figure out what interest she owes on the mortgage fraud issue, which is very, very serious facing her in more than one case, I might add. I think it's a slam dunk. We'll see. But of course, it's unprofessional. This woman should not be a lawyer. The fact that she got elected talking about she's going to indict somebody, she's going to sue somebody. People should be very concerned about the legal community in New York.
Could you imagine if some lawyers said they were going to sue you? You watching right now, could you imagine if some attorney out of nowhere said, I can't wait to sue you? I mean, you would take that to the judge. Your attorney would say, hey, wait a second. Before there was any accusation of anything, the opposing attorney said he was going to sue my client before any discussion of wrongdoing. The judge would toss out the case immediately.
I'm guessing that ethics complaints have been filed against her, but where do they go? They go to the same Democrats at different levels of the court system there who are making all these decisions to begin with. So I want the public to understand, Martha, this fine was so outrageous that even 4 Democrats on this court with the Republican judge had to get rid of the whole thing. They didn't say, okay, pay $10, pay $1,000. They said, oh my God, 8th Amendment, this is excessive. We got to get rid of it. They got rid of the whole thing. And then the rest of the case, they're kind of bickering over, well, what about the underlying fraud? Yeah, what about it? No, it's not. And the fact of the matter is the rest of it's going to go too. The rest of it's going to go too. But it's all unprofessional, and particularly Letitia James. And, you know, Letitia James, things go around, they come around. You're screwing around with your own mortgage. It's like Adam Schiff. You want people to focus on these things. They're going to focus on these things, and she will have her day.
Mark, I just want to remind people, and we can put up this picture of Judge Engeron. This was a bench decision. There was no jury that heard this case and decided that this was going to be the punishment. They somewhat randomly, and that's the decision that these other judges have made now at the appeals court, that it was very random and very egregious in terms of the amount that they came up with. There was no wronged.
Can you spot?
So this is John Yoo again.
Our moment-to-moment coverage of New York versus Trump continues, and the former president's attorney, Todd Blanche, is still delivering his side's closing argument. It sounds like, though, it's coming to a crescendo here. He's once again attacking the credibility of Michael Cohen, central to his closing argument, saying that the government is perfectly happy to have a witness commit perjury on the stand. The defense could wrap up at any moment, and after that, it's the prosecution's turn. Let's bring in John Yoo, UC Berkeley law professor, former Deputy Assistant Attorney General, and former law clerk for Justice Thomas. Professor, I want to come to you and lay out for our viewers what's happening. Right now, Todd Blanche is laying out the 10 reasons there are reasonable doubt. There are myriad reasons, one of which is, this was all laid out in a 1099 and documents. There was no intent to conceal. But he says something about Michael Cohen, and it's been the thrust of his closing argument. Here's what he said. If there is anything we have learned with this trial, it's that Michael Cohen does not take the oath seriously. He lied to Congress, lied to federal judges. He's a thief. He's literally the MVP of liars. Do you think that's sinking in with the jury?
I hope so, because Michael Cohen could be the worst kind of witness any U.S. or state attorney would ever want to build their whole case on. And I don't actually think you need a list of 10, although I think Todd Blanche should be praised for getting it down to 10. It's really just one, because the jury is there to decide questions of fact. The only real fact that the government has to prove here is, what is Donald Trump's mental state? Did he intend to deceive? And the only person the prosecution put on to prove that was Michael Cohen. So if Todd Blanche can just focus the attack on Cohen's credibility, that destroys the government's whole case.
Professor Yoo, jury instructions can make or break cases. They're critical. We will learn soon what is in those jury instructions. But it's confounding to me, to Lydia Hu, our producer in the courtroom, to Shannon Bream, as I'm reading their notes, that we still don't know that second crime that would elevate this misdemeanor. As Shannon Bream says, I'll quote her, this is one of those points that seems most ripe for appeal. I presume, like any other defendant, Donald Trump would have a Sixth Amendment right to know the charges against him, wouldn't he?
That's a good point. There's
That's also why the federal court, the appeals court on a federal level will overturn this. There's so many bizarre elements. They didn't really tell him what he was accused of. They charged him with 34 felony counts. These were misdemeanors that were elevated to a felony. And we don't exactly know why. I forgot exactly why, but they were the 34 payments to Stormy. Okay? Michael Cohen made 34 checks. It was like a total of $100,000. Each of them was a felony, which, by the way, the FEC dropped the case, and the state cannot level an FEC crime at anyone, but let's continue.
There's a serious question about whether the prosecution has actually violated the Constitution in the way they've concealed the second crime. Recall that the first crime is just a misdemeanor, this bookkeeping entry business. It only becomes a felony, which is something worth jail time, if it's used to cover up or to enable some greater felony. The prosecution has still to tell us what that second felony is. It's actually hard for the jury to decide whether Donald Trump's guilty or not if they don't actually know what the crime is. Now, a good judge, an impartial judge, would send this case back to the prosecutors and say, you can't proceed any further. Instead, Judge Merchan just sort of let it go, see what's going to happen. He'll still have another chance, I think, to decide whether the whole case should be thrown out because of that legal vulnerability on the part of the prosecution.
Do you think he'll take that chance?
I hate to say it, I don't think so. Every time that Judge Merchan has had a really serious choice in this trial, he has sided with DA Alvin Bragg.
So this is something amusing. This is Professor Alan Dershowitz.
Show your
on Michael Cohen.
Alan is Fox News legal analyst Greg Jarrett, Harvard Law professor Alan Dershowitz. Professor, let's get your take on where we are in this case, this trial, and what you thought happened in the courtroom today. Where's the crime and what is the crime? Can you please tell me, Professor, because I don't know.
I've been doing this 60 years and I can't find the crime here. What I can find is a crime committed today in the courtroom by Michael Cohen. He looked the jury in the eye and he lied. They asked him why he tape recorded his client. And instead of saying, well, maybe I was afraid, I needed some protection, he made up this whole story about why he did it for a pecker. And nobody is going to believe that. And I think this raises serious ethical problems.
Of course he didn't do it for pecker. Let's continue.
For the prosecutors, in 60 years of doing this, I have never put a witness like Michael Cohen on the stand because I have ethics. And good lawyers don't put people on the stand who they know are going to lie, either on direct, and he lied, I believe, on direct, or on cross. And we're going to see lie after lie after lie on cross. And so we see ethical violations occurring right in front of us and lies occurring right in front of us. We don't even have to get into the issue that he lied before and he went to jail. He lied right to this jury. And I hope at least the lawyers on the jury will see through it and understand that he's trying to sell this jury a bill of goods. But if you listen to CNN or if you read the New York Times, this was the most compelling testimony you've ever seen in your life. And that's why these trials should be on television, so we can decide for ourselves who's telling the truth instead of having to understand this evidence through the prism of biased reporting.
You know, and by the way, Michael Cohen, I would argue, Greg Jarrett, based on the referral by Jim Jordan and James Comer about 6 other lies that they believe they've identified that he told Congress, he has a real, I guess it personally impacts him whether or not Donald Trump becomes president or not, because those referrals would likely go and be taken seriously if there's a new attorney general, correct or no?
Oh, yeah, at least a half a dozen other notorious lies that any fair and objective Department of Justice would already have.
So in addition to Comey and Brennan and everybody else, Michael Cohen lied under oath. Let's continue.
Arrested him and started the prosecution of him. But I will say that Cohen today failed to connect Trump to any crimes. And I know that prosecutors know that. So tomorrow they're going to try to change things, Sean. Cohen will probably do what he always does best. He'll lie. He'll say, oh, yes, Trump ordered me to falsely record these expenses as legal expenses. The trouble is that's going to be a tough sell because today he recounted all the legal actions he took that constituted legal expenses. I'm not sure he understood it because he's not a bright guy. The real test for Michael Cohen, Sean, will be cross-examination. The defense will spend a full day confronting him with his innumerable lies, and then they'll ask the question one by one. Were you lying then, or are you lying now? And once these jurors, Sean, see some of the seething, unhinged lunatic rants by Cohen on TikTok, they're going to hate him. But the question is, do they hate Donald Trump more?
So how is it that Trump's Truth Social means that he's partisan, but everyone around him, from Comey with the 8647, Michael Cohen, Brennan, all these people were on social media, they all were just venting out vitriol and venom towards Trump. That's okay, but Trump Truth Social, oh my God.
More. Will they acquit because there's no evidence of crimes, or convict for purely political reasons? That's what Alvin Bragg is counting on because, Sean, he has no case.
I'd like to know, too, how much time did he spend with the prosecution, maybe mock questioning beforehand, prep sessions with them, as Stormy Daniels had admitted. All right, here is my exit question, and I don't have a lot of time. What are the odds of either an acquittal or a hung jury?
So now you'll hear a little bit of why on the federal level this was going to be overturned even before it gets to the Supreme Court.
Jury selection in President Trump's first criminal trial will get underway. Could take days, maybe weeks. The 12 jurors ultimately seated, along with some alternates, will be asked to consider 34 felony counts against the former president in connection with money paid to an adult film star who says she had sex with Trump and then took the money to keep quiet. Each of those counts carries a possible 4-year jail term. Prosecutors are trying a novel legal theory that elevates misdemeanor charges related to falsifying business records to felonies by claiming they were falsified to conceal another crime.
This is how unbelievable, like how overtly partisan political. These were misdemeanors, but then they said he tried to commit another crime with these misdemeanors, so they're now felonies. They tried to imprison this man before an election. And then they talk about norms and traditions. I mean, you can't even make it up. Then they use a dossier funneled through the U.S. government, literally purchased by his direct political rival, breaking numerous laws pertaining to conspiracy statutes. They used their government posts to conspire against an innocent man. They said he worked with Russia. I mean, you'd have to be a complete imbecile to believe that. The second they were accusing Trump, I said years back, this is complete nonsense. But it's like they can get away with anything. And then when Trump says, hey, you committed crimes going after me, oh my God, it's partisan.
The case is expected to take a couple of months. It will not be televised. High-profile witnesses may include former Trump fixer Michael Cohen. The defense will try to paint him as unreliable and self-interested. It's possible former Trump.
He wasn't a fixer. Who are Hillary Clinton's fixers? You've never heard them. They're only attorneys. God forbid any Democrat has a fixer.
Trump aide Hope Hicks. Stormy Daniels herself and another woman who claims she had an affair with the president could take the stand, but will the former president? Let's ask someone who could answer that question. Joining me now, attorney for the former president, Will Scharf. Good to see you. Welcome to Fox News Sunday.
Great to be with you. Thanks so much for having me.
Okay, so the president, first of all, let's talk about jury selection. This is an area where Manhattan, roughly 85% of the vote last time around went for President Biden. How tough is it going to be to get a jury you think can be neutral?
Well, I think that's a really important point. At the end of the day, what we're talking about here is a show trial. It's a 6-week-long media extravaganza in the media capital of the world, where the only realistic concept consequence, even if President Trump were convicted, is frankly a talking point for the Biden campaign. Jury selection is going to be difficult. I have a lot of faith in our team up there that they're going to be able to get the best possible jury. But I think it's really important to note that the fact that this case is being brought at the height of election season makes the process of picking a jury even more difficult, makes the possibility of having a biased jury even more likely. And that's a real problem.
Well, the president a couple of days ago said he'd be okay taking the stand. There are those out there who say, one legal analyst said, if he was my client, I'd beg him not to do it. Michael Cohen, who is also expected to be on the stand, is skeptical the president will take the stand. Here's what he said last night.
The likelihood of Donald Trump being on the stand is equal to the likelihood of me waking up tomorrow 7'6" and playing center for the New York Knicks. It's not going to happen. The one thing that, every time Donald opens his.
Look at how much they love, or they look at all the love he's getting because he turned on President Trump. He turned on Trump because he had legal issues of his own. And the Southern District of New York said, you're going to go to prison for a long time defrauding a bank, the taxi medallions that didn't work out. So a whole bunch of things. And they said, you're going to go to prison for a long time. You better play ball. And he did. And then you just see, it's just so insidious. The whole thing is insidious. How they tried to get Trump. They did so in the most overtly partisan manner. And everyone who goes after Trump has their life upended. I mean, Stormy Daniels' lawyer, all these, former FBI agents. You can go on forever.
His mouth, you know that something non-truthful is coming out of it. We also know that he's not a good defendant. He's not a good witness.
He does tend to get frustrated with judges, with attorneys in the courtroom. He's given to hyperbole at times.
So there was never any chance that President Trump would testify, nor did he have to.
This is different than a campaign stop or a press conference. I mean, it's under oath. Would he take the stand? And do you have any worries about that?
I think that's going to be a decision for President Trump and the trial team, depending on how the trial progresses. I would say that I think if he does take the stand, President Trump will be a compelling witness. He did nothing wrong here. The truth is absolutely on his side. So that's a decision that's going to have to be made down the road. But one way or the other, I have full confidence in both President Trump and the team that he has around him.
How worried are you about Michael Cohen? Because he says people are going to be surprised by some of what they're going to hear. He says he's not the linchpin to this whole thing. In fact, Lenny Davis, who's been a legal advisor to him, says this: the case against Trump involves multiple witnesses besides Cohen to corroborate the crime of paying illegal hush money under New York law, as well as under federal law, backed up by multiple witnesses, documents, text messages, telephone call records, and documents.
They were citing federal law, and the Federal Election Commission dropped the case.
You guys clearly are going to go after Cohen, but he says it's not just me. There are all kinds of other things that will back up my story.
Well, look, and I'm somewhat limited in what I can say here because of the wildly unconstitutional gag order entered against President Trump by Judge Merchan in this case, which just goes to show how outrageous this whole process has been. With respect to Michael Cohen, as we've said consistently in pleadings, this is a man who numerous courts have found guilty of perjury in the past. And I think ultimately the jury is going to have to weigh the credibility of the various witnesses. But I truly believe that truth is on President Trump's side, and there's nothing that any of these witnesses or anything the New York DA can do to change that basic fact.
Would the legal team consider this idea that's being floated out there of when you get to the jury, before they get to deliberations, asking for lesser included offense, meaning giving them an opportunity to say, we will convict on misdemeanors instead of these felonies? Or do you guys want to go for broke as felonies or nothing?
Well, one of the craziest things about this case, and you teased this a little bit in your intro, is the fact that what we're dealing with here are misdemeanor offenses that through this weird legal alchemical process, Alvin Bragg has attempted to convert into felony offenses. If these were merely misdemeanors, there's no question the statute of limitations would not allow this case to have been brought in the first place.
You have people who committed the most violent crimes imaginable being let out on bail throughout the country. Then with Trump, without even his money, it was Michael Cohen that Michael Cohen gave $100,000 of his own money without any evidence that Trump told him to do so. There's zero evidence. Okay. Now, it's likely It's likely that President Trump, at that time, candidate Trump, said, yeah, do what you have to do. It's likely. But there's no evidence. Anyway, let's continue.
So that's a real legal problem with the case itself, and I expect that will play out in court in the coming weeks.
Okay, and we're out of time, but I know that you are part of the...
And we'll wrap it up with Hans A. von Spakovsky again. There was no crime.
Hans von Spakovsky is a senior legal fellow at Heritage Foundation and a former Department of Justice official under President George W. Bush. He believes Cohen did not violate campaign finance laws, and neither did the president. He joins me now. Hans, this is a really hot article. Rudy's been forwarding it. The president's been waving it around in the air. I've been talking about it on the 5 all week. I claim all the credit. Besides you, of course, for writing it. In simple terms, because we're going to be talking about this probably for the next 2 years, was this payment to Stormy Daniels illegal before the election? You say the Federal Election Commission, the Federal Election Campaign Act would say no, it's perfectly legal.
Yeah, and the reason is this. You can't use campaign funds to pay personal or business expenses. You can only use campaign funds to pay campaign-related expenses.
Right.
And the FEC has said in the past that this kind of a payment, a hush money payment, that's a personal expense. That's not related to your campaign.
And it was actually paid for by Trump, not the campaign.
No, that's right. And the reason we know that the FEC would not consider this to be a campaign-related expense, and that's important because if it's not, then all the rules and regulations in federal law don't apply. But remember, the Justice Department tried to actually make this same argument once before when they prosecuted or tried to prosecute John Edwards.
Right.
They're actual contributors. Contributors were making payments to his mistress who was working for the campaign.
Right.
A jury didn't buy it, but the FEC also didn't. They audited the Edwards campaign and said, these are not campaign-related expenses.
Right. Now, so let's just put this into perspective now. If you're in Congress, and we know Congress has this slush fund, which pays out sexual harassment, sexual misconduct settlements that, require people to hush up afterwards. They run for re-election every 2 years. I mean, it's in the window of a campaign, of course. Millions of dollars is going out. That's taxpayer money. That's not being reported on FEC filings. So what's the difference?
No. No, in fact, if you take to the extreme this weird theory that the U.S. Attorney in New York has, all these members of Congress are using taxpayer funds to pay for campaign-related expenses, which I think is very problematic.
I mean, if you just give that argument right there, it's game over. I just don't see how people, because everybody on the left is saying, oh, you know what? He pled to a campaign finance violation. That's it. The president's now on the hook, and let's impeach. You're saying you don't see any evidence in the case histories and these acts. I mean, you have codes here you cite, and I want everybody to read this article by Hans. Trump's ex-lawyer didn't violate campaign finance laws, and neither did the president. It's all over the internet. You can't even spend money. I mean, what if you got a haircut before the election? I mean, out of your personal wallet. I mean, is that a campaign expense if you don't report it?
Well, look, under that theory, it is. I mean, I'll give you another quick example. Look, if you don't pay the mortgage payments on your house and a bank forecloses in the middle of your campaign, obviously that's going to hurt your reputation and may influence the outcome of the election. But that's still not a campaign-related expense. That's something you have to pay out of your own funds. You can't use campaign money to do it. And by the way, if, in fact, a candidate were to use campaign funds to pay off, for example, a mistress, I can guarantee you that FEC would be going after them saying, you use campaign funds for personal expenses.
Right. All right, Hans, there it is. I suggest every Democrat in the country read this article.
So, ladies and gentlemen, this is huge. Huge victory. Go to H.A. Goodman's other channel right now. The segment will be up in about 6-7 minutes. Thanks, everybody. Hit subscribe. TBJ to my super chat. Thank you. Thanks, everybody. I'll see you tomorrow. I'm thinking